Thank you for joining us this afternoon. We're still waiting for a couple of people, but we're not going to wait much longer. Your time is valuable, so we don't want to abuse your kindness to be with us this afternoon. So during the presentation, just a couple of housekeeping matters. During the presentation, we're going to mute your audio, so you won't be able to speak while we're doing the presentation. At the end of the presentation, we are going to ask you to please unmute your phones or your microphones if you like to ask a question. We're going to have enough time for questions. My name is Angela Lopez. I'm an attorney and shareholder and lead of the immigration section of our firm. I have been practicing immigration exclusively for a little bit over 20 years. And with me tonight is attorney Michelle Alonzo.
Thank you for joining us. I'm a shareholder also here at the practice group at Cowles Thompson, and it's a pleasure to bring these informative webinars to you.
So tonight we're going to be talking about what the title says. But one thing I forgot, sorry. The questions. You'll have time to ask questions at the end, but you can also use the chat feature to type your question. However, we're not going to be closely monitoring the questions throughout the presentation. We might answer the question at the end of the presentation. But you can type it so you won't forget to ask you whatever question you might have at the end of the presentation. Today, we're going to be talking about H-1B visas. And H-1B visas, specifically the registration and the application process. As you might know, last year, there was a new change, and now employers are required, and this might be the last year from what we hear from the new administration, that employers are going to be required to register, but that is yet to be seen. Before we start talking about H-1Bs, registration, and I just want to give you some update as to what happened last year with the new implemented system. So last year we did the registration and we went through the dates, meaning employers, we started creating accounts on February 24, employers start filing, or we started filing petitions to register companies on March 1st. Announcements by the Department of Immigration were made at the end of March to let employers know whether or not they were selected. And then employers were given from April 1st to June 30th to file the H-1B CAT petitions. However, according to the Department of Immigration, they did not receive enough H-1B CAT petitions at the end of June to fill all the 85,000 visas that they have available. Therefore, they did a second lottery. What I want to make clear that it's not that they didn't receive enough petitions. They did receive more than 200,000 registrations. But when they did the first lottery, not everybody that applied for, that was selected for that lottery submitted a petition. So at the end of the 90 days, there were still slots left. So they had to run a second lottery. And in August of 2014, some employers and attorneys started to get notices from the Department of Immigration, letting them know that they could file, because they were selected, the petition, and they were given until the end of November to file the petitions for the second lottery. And some of them did, most of them, and then this year, at the beginning of the year, actually at the beginning of February, employers start receiving notices from the Department of Immigration, letting them know that they filled all the 85,000 petitions, and therefore the H-1B cap was closed for the year 2019-2020. So that's what happened last year. They did two lotteries, and some people got selected after they thought they didn't have a chance, after they didn't hear from the Department of Immigration in March. The registration process. is electronic, meaning employers since last year have to register with the Department of Immigration, and registration process or term starts at noon Eastern time on March 9 to noon Eastern time, March 25th. That means that employers who want to apply for a H-1B CAT petition must submit the petition or the registration. The only chance they have is March 9th to March 25th. That's it. Accounts can be created starting February 24th. For those who already have an account, like we have for some of those that were not able, or they were not selected last year, we have accounts. We will be updating those accounts, but the accounts are already created. Those who don't have accounts, they can start creating those accounts this week to start filing the petitions. I'm sorry, on May 9th, on March 9th. Selection process. So on March 25th, they'll close registration and then they start running the lottery. It's going to run from March 25th to March 30th. And then they will let employers know if they were selected, only to the selected ones. The ones that are not selected, they can look in the system in their accounts to see what the status of the application is, and we'll show you what means status. So the way they are running the registration or the selection is very particular. They started doing this the year before in 2018. And what they do is they take all the registrations that they receive for bachelor's or advanced degrees. And advanced degrees is people who have master's degrees or higher degrees in the United States, colleges in the United States. So they first do the general pool, which means all of the petitions, master's and non-master's, advanced degrees or not advanced degree. And they select the first batch of H-1Bs. And then if they are more petitions, advanced degrees left or registrations, then they run the second pool, which is the advanced degree, master's or other or higher from American colleges pool, which means that people with advanced degrees from US colleges have a better opportunity to get selected to apply for an H-1B visa CAP petition than people who don't have an advanced degree in the United States. Employers are definitely notified by no later than March 21st, 31st, and then they can start filing the petitions from April 1st to June 30th. What is the process? The process is very simple. Their USCIS, you can see there, they have a website, is myuscis.gov. Employers can log in, or attorneys. This is the portal that we use to register employers. We log in, we create an account, and the account basically contains the employer's information. If it is an attorney representing an employer, then we have to include that information, and the employer has to confirm that, yes, this is my attorney, and they are allowed to file an H-1B CAT petition registration on my behalf. What is needed to create an account? Well, you go into this portal and you select the type of account you are creating. You can select, I am an applicant, petitioner, or requester. This is if the employer is the one filing the petition. I am a legal representative. That would be for me if I am the attorney filing the registration on behalf of my client. And I am the H-1B registrant. Then you go next. When you click next, then you have to provide the employer's information. And it's basic information what they're looking for. At this time, they're not looking for all the information that you have to include when you're filing the actual petition. Remember, this is only an application to register the company and the individual that they want to sponsor for H-1B, therefore, is only an online account. The employer's information, obviously, the company legal name. I always advise people to take a look at the IRS letter that assigns the federal identification number to employers, because that's the best source to give you the exact name, the legal name of the company. However, be aware that sometimes companies change names, and not necessarily the IRS letter is going to give you the legal name. So you need the legal name. You will also need the doing business as. Many companies use. Obviously, the federal employer identification number, the primary US address, meaning where is the company located. And then you have to provide the information of the person that is authorized on behalf of the employer to sign the petition, to submit the petition, and that's the contact person for USCIS communication purposes. Then after you complete that information, you also have to provide the information about the beneficiary or the H-1B, prospective H-1B employee. And again, basic information. All of this is within this account. Legal name, full legal name. Gender, date of birth, country of birth, country of citizenship, passport. Make sure you include the passport information, because whatever passport you include on this petition, you have to include it in the H-1B petition, because when they select the petitions, they give you a notice saying that you're selected, you can file your petition, and your petition information should match the information that was entered in the online account when the employer was registered. It can happen that at the time you are going to submit the petition, the H-1B petition, the person might have a new passport. That's okay. You will include the new passport, but make sure you also include the older passport that was the one used to create or to submit the registration. So that will match the records. And the degree information. This is important because here is where employers have the opportunity to let the Department of Immigration know whether or not the registration or the application, if selected, is going to be filed as a bachelor's regular H-1B or an H-1B competition advanced degree. Make sure the individual, the employee, has the respective degree when you are filing the petition, when you're filing the registration. That doesn't mean they have to have the diploma in their hands. Sometimes people complete the classes, or they know that by May they are going to be fully graduated with the advanced degrees, with the master degree. So you could, if you know for sure you're going to have that master's degree by the time you have to file the petition, then you select that information when you're doing the registration. If you don't know if that person is going to have that master's degree, and it happens, then you should select the bachelor's degree to avoid not being able to file the petition, because at the time of filing, the individual or the prospective employee was not able to obtain that master's degree, and then you will be out of the queue. Which means is, if the information you're submitting the registration cannot match the records, meaning the degree you're submitting the H-1B, therefore you cannot file the H-1B petition. Electronic registration process, there's a fee, $10, and it's more symbolic than anything else, but it's a $10 fee that has to be paid at the time the registration is submitted, and you can pay it by withdrawal from a checking account, meaning you enter the routing information for the checking account so the USCIS can withdraw the $10 from the account, or by debit or credit card. In my case, I prefer to do the credit card. It's easy, simple. Withdrawing from checking accounts sometimes can be a little complicated, but either method is okay. Maximum of $250 per registration. What that means is employers who have multiple prospective H-1B employees can file up to 250 registrations when they're registered per application, meaning they open an account and they can include up to 250 individuals in there. Of course, they have to pay the fees for each one of them. It's not $10 for 250, no, it's $10 per individual. And that brings me to employers are allowed to file multiple H-1B registration petitions for different employees, multiple employees. But they can file multiple H-1B registrations for the same individual because the USCIS will cancel all the registrations and that employer will lose the opportunity to file for an H-1B cap petition or at least register to have a chance to be selected. At the same time, individuals, employees, or prospective H-1B employees, they can have more than one employer filing an H-1B registration on their behalf. They can't have is the same employer filing multiple petitions or registrations on their behalf. Two different scenarios. When the registration is filed, we took a copy of the actual website. So what you're going to see is once the petition is submitted, registration is submitted, then the status of your petition is going to say submitted. And you can open and see the PDF version of the submission. And then the account stays submitted until they run the lottery. Once they run the lottery, if you don't receive an email from the Department of Immigration or your representative attorney doesn't receive that email saying you were selected, you may proceed and file your H-1B visa, then you can go into your account and check what the status says. So the status should say either selected. If you were selected, you can check that on March 31st. Last year, I remember it was at the end of the day, we started looking, and we were able to see when they updated the website. So if you're selected, it's going to show selected. If it was denied, because it was a duplicated or something, it will say denied. And remember, when employers are filing multiple petitions for the same employee, or just submitted. If it was not selected or denied, it will stay submitted until they complete all the lottery, which means that, like last year that they did 2 lotteries. The status of the cases that were not selected stayed submitted until early in February, when they finally updated the petition to say the website to say not selected. That's because they run the 2 lotteries, they completed the number of applications they were going to grant H-1B visas, and therefore they were not going to do any more lotteries. Petitions were not being denied, so meaning registrations were in good standing. Unfortunately, they were not selected, so the status changed to not selected. H-1B, as I mentioned, if it is not selected, it's not selected. This year they took forever. They just let us know in February, and they let us know in February, not selected, just when they were announcing the new dates for submitting petitions. In this year, the dates that you have to remember, oh, I see, I made a mistake on my slides. The dates to remember, February 24, create your accounts and get them ready to file the petitions on March 9. I will be fixing that slide there, but it's March 9, not 1st, March 9 at noon, you can submit your registration, and you can continue to submit registrations until March 25th at noon Eastern time. Lottery will be run from the 25th to the 31st or the 30th, and people will be notified if selected. And then from April 1st to June 30th, the first selected applications can be, employers can submit their H-1B petitions. Petitions not received by the Department of Immigration by June 30th, they lose the slot, and then employers cannot file that petition after June 30th. Second lottery, question mark, we don't know. last year they did it, this year all, it depends on whether or not they receive all the selected petitions between April 1st to June 30th to determine whether or not they will run a new petition. Again, the key here is submitting the petition on time. Don't wait too long. Get it in as soon as you can. And if you're selected, you can start filing those petitions on April 1st through June 30th. This is crucial, especially for F students who are on OPT, because many of these students that have OPT, they have the opportunity to get their OPT extended, that is the gap, the cap gap, because for some of those students, the OPT or employment authorization expire sometime in May, sometime in June. So if the petition is filed before the OPT expires for change of status, the school can file, submit a renewal of their OPT and extend their work authorization beyond the expiration date, May or June or July, at least through October 1st, when the new H-1B or the new status is supposed to take effect. So for F1 students and OPT expiring sometime in the summer, you want to file your H-1B petition, if it is selected, as soon as possible after April 1st.
Angela, we have a question in the chat.
Yeah.
And I think it fits right in here. The question is, if in this scenario, if an applicant is not selected, can they apply again the following year?
Absolutely. And that's what we're doing now with a few of our petitions that were not selected last year. Because not being selected means you just didn't make it. So your petition for registration, you should be filing your registration again and cross your fingers that you selected this year. But absolutely, nothing will prevent you from filing again. Now, that's as far as the registration go. It is rather a very simple process. The key here is keeping in mind the dates, submitting the petitions or the registrations when the day is due. I'd rather to file them as soon as possible after March 9th, rather than waiting to the end of the 25th. But sometimes things happen and you're not able to file all your petitions on one day or as soon as after March 9th. So now, H-1B visas, and today we're not going to be too extensive on the requirements. We're just going to go through some of the critical requirements that we know are the ones we're always dealing with, because are the ones that are causing more denials than any other things when you file H-1B visa petitions. So suppose that your H-1B registration was selected. Was selected. Then you're going to be filing your H-1B visa petition. H-1B visas are regulated by federal regulations, and they were changed in H-1B Reform Act of 2004. That tells you how old these rules are. The other changes, like the process and the registration, is more about procedure than substance. But the substantive requirements have been in place since 2004, with some changes here and there, but overall kind of the same requirements. It is regulated again by Title 20, Code of Federal Registration, and there is where you find the rules related to H-1B visas.
Okay, specialty occupation. As Angela's explained, and we've gone on, the H-1B is a specialty occupation visa. And what is specialty occupation? It's specifically defined in the code. And what it is it's the occupation. It's the position must require, and you see there, highly skilled, specialized knowledge, which translates into a minimum bachelor's degree in that specific field or in that specific specialty. For the minimum entry into the occupation. So if the occupation would traditionally require at minimum an associate's degree for the particular position, that's probably not going to be a specialty occupation. You're looking, and USCIS wants to see that these are professionals, these are professional visas. So while you may have a bachelor's degree, the petition needs to be specifying an occupation that is utilizing your bachelor's degree at minimum, or a US master's. So let's see. Oh, Angela, you're muted.
Sorry, I'm sorry, I'm back. As I mentioned before, we're just going to touch on the 3 or 4 basic requirements that are the key to a successful H-1B visa. So Michelle just talked about a specialty occupation, and that's pretty black and white. Either you meet that requirements or you don't. And then the third-party location, this one is one of those that had been changed through the years and changed in terms of how the Department of Immigration defines third-party locations. And this basically relates to those employers or H-1B petitions that place H-1B employees at a third-party client site to perform services. So for example, I hire an individual to work with us at Cowles Thompson, but this person, H-1B, is going to be working off site, meaning is going to go to one of my client sites and perform the work at that specific location, which is not my location. It is my client's location, but still he's going to be my employee. For this, the norm is you have to submit documentation showing that the person is your employee, employer-employee relationship, who has control over the employment, and other series of documents like contracts showing that regardless of where the employee is located, the H-1B petitioner or employer is the one who has control over that employment. However, last year, there was a new rule that called strengthening the H-1B non-immigrant visa classification program that was supposed to come into effect on December 7, 2020, defining third-party locations. And they were following the Department of Labor definition of third-party locations, which means third-party locations are those who are not under the control of the employer, and the employer do not own or lease or have some sort of rights over those locations. And they were also trying to limit the H-1B term for those who were going to be working at third-party locations to 1 year as opposed to 3 years. Well, as you may already know, pretty much every single different act or rule or memorandum or something that the Trump administration tried to implement in many different areas, lawsuits were filed. So there was a lawsuit filed for this specific regulation, and so the regulation did not take effect because the district court for the Northern District of California blocked the rule and joined it and did not allow it to be implemented. But still, that is being litigated. That doesn't mean this is the end of that rule, and we just need to see how that goes. Not necessarily because the administration or President Trump left office means this litigation is not going to go anywhere. As we had mentioned in previous labor seminars, sometimes when administrations, when there's a change in administration or the president leaves, other groups and other interest parties can take the place of the president that has left to continue the litigation on any specific matter. So that's what may happen here. So we're still to see what will ultimately happen with this third-party location definition. For the time being, we're still working under the normal regulations.
Which brings us to the prevailing wage. This is probably some area that you've seen highlighted recently in a lot of media. And it's because it really is an integral part of the H-1B. It's the employer has to pay this prevailing wage. And what is the definition? It's defined as the average wage paid to similarly employed workers in the requested occupation in the area of intended employment. So that right off the bat tells you that they're looking at your geography and where the position is going to be and what other people are being paid for that same occupation around you. So you're not going to get presumably the same wage in a metropolitan area than you would say in a more rural area for an engineer or even an accountant, for example. So there's a lot to uncover about this. Let's go on. The prevailing wage is the obligation of the employer. They must pay no less than this required wage rate. The required wage rate is either your actual wage or the prevailing wage. So let's say the sponsoring employer pays their employees well. They can't opt to pay you the prevailing wage if they're actually paying others in that same position the higher wage. So they're either going to create that baseline, or they're going to have to use the prevailing wage for that particular occupation. So it's going to be the higher of the two. So sometimes the actual wage might be higher, the prevailing wage. If that employer's paying that actual wage, that's at minimum what the H-1B employee would be paid. So and there you have it, the actual wage level is going to be paid to all those individuals. So you have two competing wages here in some instances. And it's important though, because as you're going to see, sometimes the actual wage is lower because it takes into account actually what's happening in the area and is not part of this prevailing wage. And we're going to discuss here in a minute why that might be a little conflated. There are multiple sources that we can use for the prevailing wage. Collective bargaining agreements, your employer's either subject to them or not. So it's one of those things where when we're talking to the employer, that's one of the first questions we ask. Are you part of a collective bargaining agreement? Are you working with these outside or these organizations within to come to these wages? The other one's the National Prevailing Wage and Center. Then we have the occupational employment statistics. That one's critical because a lot of the litigation and a lot of the news is focused around those OES wages because most employers will use those OES wages. The OES wages actually are from the Department of Labor. They presumably use data from the government to, by way of a mathematical formula. So already it's a formula that I can't even begin to decode, but we know that it establishes these wages. And the last one, which has really come to center stage recently, are the employer-provided published wage surveys or employer-conducted wage surveys. There's multiple vendors that provide these wage surveys that are currently under a lot of requirements that they'll have to meet. You'll go over the requirements here on the next slide. The specificity for these wage surveys are, you'll see right there. It can't be more than 24 months old for the date of publication. It has to cover the area of intended employment. So it can't be, oftentimes regional is too big. So they really want to be specific. The survey must reflect, and this always gets me, an arithmetic mean, not a median. Okay, I don't know about you, but I've already forgotten about economics from college. So unless you're an economist, these things sound very foreign. The survey must be cross-industry, and it must be based on what they call sound statistical methods. So there are multiple vendors that have gone through that we utilize that meet all of these requirements. And perhaps the most daunting one is that it could not have been published within 24 months. And if anybody has done any sort of wage data surveys, 24 months, that's pretty tough. But again, there are vendors that have them. And a lot of these prevailing wage surveys are now coming to center stage because of what we've seen in terms of this, I guess you'd say, manipulation of this prevailing wage. So Angela had precluded to it in terms of third-party location, but we're dealing with the same issue. Again, in October, the DOL issued that strengthening wage and protections for temporary and permanent employment. This was an interim final rule. As she mentioned, litigation ensued. We had the change of administration. This is where you see a huge impact in the change. I'm going to spare you all of the courts that came in, but just understand that as of January 14th, the courts, there's 3 courts that struck it down. They said no. So January 14th of this year, very close to the inauguration, the DOL issued a final rule adopting that interim final rule that's been struck down with changes. They did some legal maneuvering, real creative legal argument in trying to push forward this change. And then the administration came back and said, no, we're going to put a moratorium on these, what they call, not moratorium, it wasn't permanent, but they're putting a pause on what they call midnight, these midnight changes. And what resulted is earlier this month, February 1st, they actually said they're going to delay the effective date of this final rule on the computation of prevailing wages until May 14th, 2021. And that date is critical based on the timelines that Angela was explaining, because the lottery starts and it technically doesn't end until all those numbers have been used. And you're going to get cases that are going to fall after this May 14th, 2021 date if there's no additional changes. So we, and Angela and I were discussing this earlier, we haven't heard what else is happening in terms of litigation to stop this implementation or this effective date of May 14th. And we're obviously keeping a very close eye on it because it's going to impact cases tremendously. I have a couple of examples, but just to give you some orientation, there's 4 wage levels for this prevailing wage that exists. This is created, and there's new wage percentiles that are issued. So for example, the level 1 wage is entry level. Think, I just graduated. If you're F1 OPT, chances are you're going to be sponsored for an H. You're going to be coming in entry level. Level 1 is baseline. Level 1 is saying you need at minimum that bachelor's degree. The wage is being increased to the 35th percentile of the OES wage distribution. And you can see as it goes down, level 2 is increased to the 53rd, level 3 to 72nd percentile, and level 4 to the 90th. This is a drastic change. You'll see there on the slide, they're currently, for example, level 1's at 17%. So you're going to see this sounds like foreign language. So let's look at actual numbers. Now, this was taken from a Forbes article about it. What you're looking at, for example, right there, you have an increase across just a sampling of these specialty occupation software developers, an increase of 29% for a level 1 OES wage. Database administrators, those are really big, 29% increase. Biochemists, 34% for entry level. So it's mind-boggling. So let's look at actual numbers. For example, if you're looking in the San Jose, Sunnyvale, Santa Clara area, right? This is the actual metro statistical area where the wage is set. Currently, the level 1 wage by the private wage surveys, this is data from real people. They're reporting it. They're saying this is what is being paid. That entry level position is going to pay $77,908, right? Under this new DOL mandated minimum salary, a level 1 entry level position is going to be paying $114,000 to be able to get your H-1B. That is a stark increase. I mean, you're looking at $36,000 for I don't know employers that are going to be willing to pay $114,000 for someone fresh out of school in an entry level position. So it's highly suspect. And you're looking at, for example, of the level 4 wage. I mean, these are obviously senior executives but senior position people within that occupation. I mean, a $54,000 increase is just, $41,000 is just astronomical. So you can see on the presentation, there are, the first one got struck down, right? That's the 1020. They said, nope, you can't do it. So then they came back and said, okay, we're going to make adjustments. But you'll see those adjustments are really modest. They're not what we would have hoped. And quite frankly, it goes back to the prevailing wage being based on a formula that can be manipulated or sometimes tweaked to a certain wage. It's just, it doesn't seem to help much. For example, the level 1 wage, the current percentile is a 17th percentile. Under the proposed rule from October, you're looking at a 45th percentile increase. Under the more recent one from January, they brought it down to 35 percentile, but that's still almost double from what we currently have. Again, it's just not, it seems very hard and punitive to employers that want to hire foreign workers.
And
so
in reality, just to add to what Michelle is saying, we hear frequently from employers when we start looking into filing an H-1B and we start looking into salaries and the prevailing wage and the DOL data, frequently we have employers saying that the numbers and the salaries established by the Department of Labor are not realistic, that they don't even pay their own US citizen employees that high of wages. And we've seen through the years that some employers, they just can't file H-1B visas because they are not able to meet the demands of the prevailing wage requirements, not because as you hear in the news, is they don't want to pay or they want to underpay professionals under an H-1B visa or pay less than they would pay to US citizens and all the things that you hear, but because market-wise, that's not what the salary for the specific position in the specific area is, other than the Department of Labor decided that's what they want people to pay. So it leaves some employers out of the equation. And if this rule becomes effective, and honestly, we hope not, then it's really going to affect a lot of employers in terms of their capabilities of filing H-1Bs, because they might not be able to pay these high salaries.
Exactly. And one of the ways that we have, some particular employers, for example, don't want to lose a candidate. And let's say they get selected. One of the options, and we've done this with a couple of employers, the H-1B can be filed for full-time or part-time. So if it's part-time, it's going to be based on the hourly wage. So let's say they really want you to come in entry level, but they can't afford the prevailing wage for the salary on a full-time, so 35 hours or more. One thing the employer could look, if they really want to retain a candidate, is maybe consider if they would entertain the part-time on the hourly, and that might be within the reach of the employer to pay, because there's no way to get around the prevailing wage requirement. So that's been a creative way that we've seen a couple of employers go about it, but sometimes they can't afford the job to be done on a part-time basis, and so we're just out. Yep. There is a question in the chat.
Go ahead.
Okay, I'll go ahead and share the question. My current OPT is set to expire on 1/31/2022. Will there be a possibility to reapply in 2022 if I don't get selected this year?
Yes, definitely. We just covered that if you're not selected, then you can reapply next year and the following year and the year after that until you finally selected. Absolutely. There's nothing that prevents you from reapplying for the lottery again. Although we don't know what the lottery is going to look like next year, because
exactly.
Yeah, because even before President Trump left the office, there were already people requesting that the lottery system was changed to something different. I don't know if they want to go back to filing petitions and then USCIS returning the petitions that were not selected. I honestly think that this registration process, other than the weird thing they did about doing the second lottery, and because I need to know how that worked, because it's not very clear to me, but I think it's more practical. And it actually incentivizes employers to file, because the registration process, they're not making a huge investment in terms of big attorney's fees or big fees to the Department of Immigration, although if the petition is returned, they return the filing fees as well. But they're not making big investments in terms of getting an H-1B petition prepared and filed with the Department of Immigration, then to get it back in a few months if the petition was not selected. The registration process kind of takes care of that problem, and to me was more practical. But hopefully, if this is going to be replaced, it's going to be for a better system, not worse than the one we had before, right, Michelle?
Right. But what about premium processing, Angelo?
Well, we were talking about that this afternoon, and we don't know. Traditionally, they have suspended premium process during the CAP submitting initial submissions. Last year, because they did the registration, they actually did not suspend the premium process initially. So many of the petitions that were filed, they could be filed under the premium process system. And so we did it. So this year they might do the same depending on the volume they're going to be receiving, depending on how things are going. But last year they did not suspend the premium process during the time, meaning April 1st to June 30th, when the CAT petitions were supposed to be filed. The problem we're seeing with H-1Bs, and this is just a bonus here because was not even intended to be in the presentation, is the H-4 petitions, right, Michelle?
Yes. The H-4 petitions would be filed, obviously, with the change with the H-1B, but those adjudications are taking so much longer. And hopefully we're going to see with the change of administration, part of the executive orders and presidential memorandums that came out in January were to encourage DOL, USCIS, and ICE to revamp and look at all these processing delays. That has obviously been a huge highlight, and it's a complaint from all stakeholders in these situations. So hopefully we're going to see more, some sort of addressing these delays and backlogs in processing, because your H-1B could be approved, but then you have your dependents who are just sort of sitting in limbo and they can't leave because the petition's pending, and you can't leave while you have a pending change of status or a petition. It's really bizarre and incredibly complicating.
Yeah, so that was the bonus part of this, and we'll talk about, I will do an H-1B presentation once we get through the registration. Then we are here. Questions.
So we have a couple comments. Not even my boss makes $147,000.
Our point precisely. It
yes.
is unbelievable. We're going to open the lines. Please if you're going to ask your questions, ask them clearly. If there are any questions on the chat, Michelle, if you can please read in. Yes. Otherwise, please unmute yourselves and ask the questions. We're happy to answer.
So it looks like we're in the chat box. The last question, OPT expiration of 1/31/20 does not pose a problem. Absolutely not. Like Angela mentioned, it doesn't. Now, it would be problematic. For example, you wouldn't be able to get cap gap protection if you filed in 2022. Correct, Angela? If you had, she's ending 1/31/2022, but say we're filing.
Yeah. Well, because cap gap only works if you're filing the petition when you still have a valid OPT or employment authorization beyond the day of the filing of the H-1B. For example, if you are selected and you can file your H-1B to change the status on April 1st, you're supposed to have some sort of validity on your EAD beyond that April 1st. Otherwise, cap gap wouldn't work.
Okay, and a follow-up. This is interesting. This is especially in light of the COVID. I like this question. Can an OPT student that's currently outside of the US working remotely return to the US on the F-1 visa after the employer registers for the H-1B?
Go ahead, Michelle.
Okay, so here's the crazy, bizarre thing about the F1. If the F1 is still valid, that you can. We've had it go both ways, and honestly, there hasn't been a lot of international travel because of visa bans and everything over the last year, as everyone is well aware. Um, I have, and we don't recommend that people travel outside once they're on OPT if their F1, for example, is expired. But if the F1 is still current and you're on OPT, oftentimes what we have sent clients with is their letter of employment verification that they're on OPT. And obviously they have their EAD and they've been allowed in, but it's not a guarantee. Just like every visa, you're not guaranteed admission. So for some reason, if the CBP officer doesn't want to admit you, you won't get admitted. That's why we often recommend folks who are on OPT and are traveling to be mindful. They need to, come back. It hasn't been too problematic, but it's not a guarantee.
Also, you need to be aware. If you look at your OPT, which is your EAD, employment authorization, it does actually says this document is not valid for traveling or to travel, which means that is not authorization for you to be traveling back and forth. But like Michelle says, but we've seen people that come and do and travel what OPT, and when we tell them these things, they look at us like we're from Mars or something, because they say, but I've been traveling with no problem. Well, until they get into trouble with the Department of Immigration or the CBP officer at the port of entry. EAD is not a travel, it's not travel authorization. And if individuals are going to be traveling while at OPT, well, then first of all, talk to the schools. They need to validate the I-20 as long as you stay in F1 status. But like Michelle says, sending when you go out, get the letters and all those things. But no one can guarantee you're going to be allowed to enter the United States just because you're coming on your F1 OPT. The H-1B would not affect you in terms of will not prevent you from returning to the United States, because the H-1B is a dual intent petition. And your F1, you're not saying with your F1, well, I file an H-1B, so I don't have intent to return to my home country. No, that's not what you are saying. So just having an H-1B pending should not affect your F1 visa to return to the United States, if I understood the question.
I believe that answered it.
Yep. Okay. Any other
Okay,
questions?
we have yes, I have my company is located in Atlanta and my office is located, okay, my company is located, so I'm assuming this is corporate headquarters is based in Atlanta, but my office is located in Northern Virginia. Would I fall under third party location, I guess, but in terms of the paperwork?
Not necessarily. If you recall, when we were talking about third-party locations, we mentioned specifically those are the locations that are not or that do not belong to your employer. So if the location you are is part of your employer's sites, like they own it or they lease the space or they have control over the space, or is how it is tied to your employer. It should not necessarily be a third-party location. Third-party location is the location you are working at doesn't belong to your employer. It belongs to somebody else. It's not owned or controlled or leased by your employer. That's a third-party location. So if your company happens to have a place where you are sitting, where you do your work, then it should not be a third-party location. Third-party locations are very specific. It is an H-1B petitioner has an H-1B employee working at a client's side or at a different site that they don't own. So that's what defines whether or not it's a third-party location.
And in terms of remote work, it looks like there's a follow-up. Let's say the employee is remotely in Northern Virginia, but the company is based in Atlanta.
Yeah, it's remote employment. It goes back to who is in charge of the location where you're working.
Perfect.
That's the bottom line. If it is owned or controlled by a different entity from your employer, then it's a third-party location. If it is not, then it belongs to your employer.
Yes, and a lot of this goes back also to the prevailing wage, because we had a lot of workers, H-1B workers, that ended up staying home and working remotely the entire time. But originally they were going into the office. And we even had some employees who, you know, say they were living in one city working, but their employer allowed them to remote. They went back to go be with family, like say in Texas, where we are. And in those situations, the DOL it goes back to prevailing wage in terms of the labor condition application, which we didn't really go into in great detail because that's a whole other presentation in and of itself. The labor condition application in regards to posting requirements, this is all part of the H-1B application process that we have to know where the employee is, because it goes back to these wages. So definitely we're also monitoring any updates in regarding to how the DOL and USCIS is going to handle this entire new concept that isn't really new in terms of remote work, but it's very new in terms of how USCIS and DOL is being forced to deal with remote work.
And that's a good clarification. But talking about if you work from home, yes, your employer may not have control over your home, but he does have control over your employment. And you're working for your employer from your own home, but is the employer the one that controls what, when, how, and pays anything related to that employment. If you're working at the third-party location, usually the client, the end client, is the one that kind of oversees that the work is done according to the specifications that they arrange with your employer. But you are off-site and somebody else's at somebody else's location, not your home, somebody else's location, performing the work for which the employer was contracted for. So that's what the difference is. This is not about I work from home. This is about I work at a client's location. That's a third-party location. And I hope that answered the question.
Let's see. I think we have time for one more, and I think we might have come in. Do you think it will be problematic that the work can be done at home? In which case, why would the employee need to be in the US? It's
that
not so.
Yeah, go ahead, go, Michelle. You go with it.
Okay. Well, this particularly, but because again, it's not regarding the wage is tied to the location, right? Because this is how it's built. But I oftentimes tell, and when I talk to employers, it's the candidate that they're looking at. It's not where can the candidate, where do they have to be? It's can they get the job done? And so if the work can be done at home, employers will say, we provide VPN access, we provide computers, we pay for the internet, we do reviews of work, every year we do our annual reviews. There is definitely an employee-employer relationship. The argument is, it shouldn't matter where you physically are if it's a specialty occupation and you're meeting, all your requirements for the employer so that the employer's happy with you and the employer's paying your prevailing wage. So it's not so much where the work can be done, it's going to be the work arrangement.
Well, but also let's make the clarification that at the end of the day, if you are sitting in the United States doing the work, you need an H-1B visa.
Yes.
Period. Because you are sitting in the United States, whether it's your home or whether it's the building where your employer has its offices, okay?
Yes.
So if you are not sitting in the United States, we're not talking immigration, we're not talking visas, you're outside the United States, no one cares where you're sitting. You'll be an employee working remotely for an employer, and the employer will probably be paying you outside the United States because you're not even performing your duties within the United States. And I know the next question, because I have been asked that question, and who's going to know whether I'm sitting in the United States or I'm sitting outside the United States? Well,
they know.
Not only they know, but the H-1B, like Michelle mentioned, is not only employer specific, but is location specific. And if you're not going to be working in the United States, well, don't file an H-1B because you don't want to lie saying, yes, I'll be sitting in Dallas, Texas, when in fact you're going to be sitting somewhere in Europe. So no, because
Now,
the salary, the prevailing wage salary is going to be determined by you sitting in Dallas, Texas, performing the job. And believe me, if you're not in the United States, you're not going to have a 994. They'll know when you leave and when you come back.
exactly. And this reminds me of one case where we actually did have an engineer who was spending a lot of time abroad on the projects that the US company was coordinating. And it required that particular engineer to be out in Saudi Arabia. So we still had to get the H-1B because when he came in, he had to be able to work for that employer and do his job duties here. But a lot of the time he was actually spending outside at that particular job site internationally. But that goes back to counting towards your H-1B time, because the maximum that you can get in H-1B time is 6 years. So in that case, that engineer is only spending 6 months in and 6 months out. Well, they're going to be able to continue that H-1B until they maximize and exhaust those 6 years. But yes, the H-1B is going to be looking at your location here. Can the work be done remotely or you're out? I mean, if it can, it doesn't count against your time.
Exactly. And remotely for H-1B purposes is remotely within the United States. And if you don't need the employee sitting in the United States, and the work can be performed outside the United States, well, then you don't need to sponsor an H-1B visa. You just need to make arrangements so you can pay the salary. And if it is going to be in their home country, well, that you meet the employment and labor laws of the country where you're going to be paying the salaries. It doesn't become an immigration matter at all if the employee is not in the United States performing the job. Okay, well, I think, do we have any other questions? I don't see any more.
I think that's it.
Okay, great. Thank you. I did have a question that came in an email, and the question was whether an employee could change from an H-1B non-cap petitioner to an H-1B cap subject. And the answer is no, unless the employee or the person goes through the H-1B cap program registration and is selected. Because the fact that can work in an H-1B cap exempt employer doesn't make the employee exempt. It's just the employer that is exempt. So no, that change can be done without going through the H-1B cap program. Okay, so I don't see any other questions. I hope we were able to answer your questions, but if you have one more, we can entertain one more.
My boss doesn't make 140K, just saying.
More bosses, more people. Most people don't make that much money in the United States. It's unbelievable, and that's how inconsistent these agencies are and how out of reality, I would say. But yes, you're right, and we hear that complaint very frequently from employers. I don't even make that much money.
Exactly.
May I really quickly go back to the 131/2022 because it's a little confusing. So if someone doesn't, in that case, if someone doesn't get selected this year, so then they would be applying for fiscal year 2022, correct?
Yeah.
And then, but if the OPT ends on 131, so then you're no longer in F1.
You can still apply, but you will not have status to stay in the United States. So you will have to leave when your grace period expires, because even when the OPT expires, you still have a 60-day grace period. And if you don't have a way to stay in the United States, maybe extending your F visa as a visitor, but if you can't stay legal in the United States, you'll have to leave and wait and see what happens with that H-1B.
So what you mentioned earlier, the cap gap probably won't apply here?
No,
probably.
It won't. Right. It won't. Because for the cap gap to apply, the expiration has to be after you're able to submit the H-1B petition. And if you're able to submit the H-1B petition because you were selected, the first day you could file it is going to be April 1st, which means your OPT will have to expire after April 1st to be able to use the cap gap.
Okay, thank you.
Yeah. Other than that, it would just be consular notification if you were selected and approved, and you would go through the consulate to get the visa and come back in.
Correct.
So
That's
if
how it will work.
Send my F1 after, I am the one with the OPT in January 31st.
Oh,
So I could extend my F1 status until I can file and do,
well,
and just wait
that's,
until the application is, I don't understand how
to
could I.
extend the F1 is up to the school. OPT can be extended for up to the initial 12 months for up to another 24 months if you are a STEM degree and your employer does e-verify. So those are the only options to extend an F1 visa. It's not just that, oh, I'm going to apply for the H-1B registration. So can I extend my visa? No, no. You'll have to have the proper requirements or meet the proper requirements to extend your F1 visa, and you'll have to check with the school to see if that is even an option.
Yeah, I am a STEM student. I have a master's degree in IT, and I am already in my STEM. So I am already at the end of my 3 years of OPT.
Then, unless
Yeah.
you're going to be able to get into another program, a PhD, something like that, you might not be able to extend your F1 further. Yeah.
Okay. Thank you.
Okay. You're welcome. Already. Anything else?
Yeah.
No, that's all. Thank you very much.
Thank you. Thank you so much for being with us. Our information is at the end of the slide there. We appreciate your time and your questions, and we hope to see you again soon. We'll be sending copies of the recordings and the presentation, so you can expect that. We will also send a quick survey, and we would appreciate if you give us some feedback so we know how to improve our presentations in the future. Thank you so much.
Thank you.
Thank you.